Good evening, everyone. Uh, on behalf of the family and friends of Alladi Kuppuswamy, I welcome you this evening to a wonderful lecture by Mr. C.V. Mohan Reddy on democracy, dissent, and the Indian Constitution. I, I welcome you to this lecture for many reasons. My father, Justice Alladi Kuppuswamy, retired as the Chief Justice in 1982, a tenure of 80 and 82 as Chief Justice, and I was not with him then. I've only heard about it from others who are with him. When we thought of the Centenary celebration, which started in 2019, we thought that we should begin with a judge and end with a lawyer, because my father practiced law for many years and served as a judge for a number of years. In those days, it was considered very long, 67 to 82, 15 years as a judge. So we had the first talk in the Judicial Academy, which Justice Chalamesh was kind enough to give. Many people do not know that my father was instrumental in starting the Judicial Academy in Hyderabad. It has now grown enormous in size. He believed that a judge is also a teacher, a learner, a student all his life. And so the Judicial Academy, and then we had a seminar, and thanks to the person here, she's right there, Kalpana Kanabiran, we organized a seminar in CSD along with her. And we had lawyers, judges, activists. The first half of that seminar was personal reminiscences, and I have here Justice Jagannath Rao Garu, who knew my father very well. He was one of the speakers there. Justice Raghuram was also there. And we had a whole slew of judges and lawyers not from here but from outside, and on diverse subjects. And after that, we thought that we should end that year in 2020 in the High Court itself. And we had approached Mr. then President of the High Court Advocates Association, Mr. Mohan Reddy, and then with him and Justice Chauhan, the then Chief Justice, we had organized a lecture by Mr. C.V. Mohan Reddy in the High Court. Unfortunately, they say man, or here I would say woman, proposes and goddess disposes, the goddess of justice. So we could not have that lecture in the High Court. In a way, I'm thankful, because 3 years later, there was a rethink in the family and among the friends. And we thought that the High Court today is not the kind of High Court that was there during my father's time, where we could go with our friends, family, or others into the High Court premises. Now there's a lot of security in the High Court. And so I approached Mr. Raghunath Veros, who was very kind enough to agree to go along with us and arrange this lecture of Mr. C.V. Mohan Reddy, even if it was in the High Court. But we decided that we would move it to the city. Another reason that we moved to the city was that my father felt that the lay people, ordinary people too, should have the benefit of the lecture. And that's one main reason why we have moved on to this campus. And I'm very happy and thankful to all of you who have taken the trouble to come on a Friday evening and to attend this lecture. And I'm sure you'll go back very, very happy and agitated. I would love you to be agitated before. As a teacher, I would always tell my students that when you go out, you must be agitated enough to think, okay? That's what a good lecture does. Another thing that I was very happy that Mr. Mohan Reddy agreed, and here I have to thank my friend and lawyer, Mr. Manohar, who put us in touch with Mr. Mohan Reddy. And he was reticent, but we were also looking at a lawyer. I knew about him because I'm also taking recourse to the Google machinery and trying to find out about people. But apart from that, Manohar had spoken a lot about him. And also the fact that I wanted a lawyer, not just I, but everybody in our family and friends wanted a lawyer who may have appeared in front of my father. Okay? So it was a very difficult task also. And we were very happy when Mr. Mohan Reddy agreed to give this lecture. And when he gave the topic, I was ecstatic. You know, he said he wanted to talk about democracy, dissent, and the Indian Constitution. I have grown up, and my brother will vouch for it too, who is here, Alladi Sitaram, that we have grown up in an atmosphere which is very democratic. And we have had innumerable arguments in the house. We have had people belonging to different views in life. There have been people who are very, very religious, people like my father, who was a humanist, but who believed also that there was an outside force. There were agnostics, there were atheists in the family, but we all argued, we all discussed, we all dissented. I didn't know when I was young that there was this word called dissent, okay? What I thought was that I had another opinion and I have a right to express that opinion. And we did have discussions. And I must recall here, Professor Hargopal one day walked into our house unannounced, and at that time my father and I were having an argument. And he said, this is wonderful to come into this house and see you having an argument, because that's what life is all about. So when he said this, I was so happy that he agreed to give this talk, and it was his choice, and it's a choice that my father, wherever he is, and I feel that he is here with each one of us, would be happy that he is giving this lecture. My father had a zest for life, and therefore I feel he's here with us, because even on the last day, my sister-in-law and I were with him, and he was very keen to go back home, and many of you may or may not know, he was an avid bridge player. And his birthday was 11 days away, and we had organized a bridge tournament. He said, let's go home, we have to go. And then suddenly he had this very shooting pain. And then he wanted to live. So he said, call Dr. Somaraju. I've never suffered this pain in my life before. Call Dr. Somaraju. He's bound to help me out of this. Because he wanted to live. He wanted to enjoy. Unfortunately, what we want to do very often, we can't do. But he is doing this in the sense that he is doing it through Mr. Mohan Reddy. He did it through Mr. Chalameshwar. He's doing it through many people who have been with us over these last 2 or 3 years. So I'm very happy, and I once again welcome you all here, all of you here, my friends, lawyers, judges, professors, academics, social activists, newspaper reporters. One newspaper reporter was a little hesitant to have tea and coffee. I said, everyone here my father believed in is a guest, and everyone has the right to eat along with us. That's the kind of democracy that my father inculcated in us. Now, I've taken a lot of your time, but I get emotional when I think of my father. So pardon me if I've spoken for more than I should have. Now, I would like to invite Justice Raghuram Garu to come on to the dais. As he is walking in, I will introduce Justice Raghuram Garu to you. Justice Raghuram Garu was born in 1951 and graduated in science from the university, Andhra University, and he got a law degree from Osmania University. My father was extremely fond of him for being an extremely good lawyer, but more than that, he thought of him as his grandson, though we are probably both of the same age. The reason being, Justice Raghuram was a junior of Mr. Venkatramanaya, who was my father's junior. So he always considered Raghuram his grandson in the profession. And after enrolling in the High Court in 1995, he practiced before the High Court of Andhra Pradesh and the Supreme Court of India. He has done so many things that I'm not going to list this, because nowadays all of us have access to information, and so I'm only going to talk to you about a couple of things that I think are pertinent, especially in the context of today's talk. That is, he was a senior counsel for various institutions, including my own institution called the University of Hyderabad. Osmania University, which is my alma mater, and he has was then appointed as an additional judge of the High Court in 1999 and became a permanent judge in 2000. What I want to emphasize are the judgments that he has given, and the judgments on freedom of speech, and in the case relating to a ban on Da Vinci Code, the film. And I would like to say here, I mean, I don't know where he finds the time, but he reads a lot, okay? That's where we used to have a lot of discussions, because he is a very, reads a lot, not just law books, not just on politics, but he has a wide range of interests. And so we would discuss a lot of things together. And he has also done on religion-based reservations, on police encounters. So you can see that he is also interested in this whole notion of freedom of speech, liberty, and the question of the individual as such. After he demitted his office as judge of the High Court, he was appointed as the president of the Customs, Excise and Service Tax Appellate Tribunal, and he delivered 35 full and large bench judgments. Now, after that, he was appointed as the first director from the judiciary to the National Judicial Academy, Bhopal. He said the rest were all academicians. I think this distinction between the academic and the judge is a very thin one, okay? And the border is very thin, because as a judge, you teach. As an academic, you teach too. So, and he is the right person to have been there. And he worked there from 2016 to 2021, and then he has shifted his residence to Hyderabad. Something that many of you may not know is that Raghuram Garu worked in All India Radio in the Yuva Bharati when he was much younger, and so is very articulate, so one is not surprised that he's so articulate and so on. Thank you, Raghuram Garu, for accepting our invitation. Now may I request Sridhar to escort Mr. C.V. Mohan Reddy to the dais. I now request Sridhar to introduce Mr. C.V. Mohan Reddy.
Good evening. This is a formal introduction to Mr. C.V. Mohan Reddy. C.V. Mohan Reddy comes from a small village in Chittoor district of Andhra Pradesh. He had his schooling in Nagarjun Sagar. He obtained his law degree from Delhi University. He was enrolled as an advocate in 1976 and started practicing in 1978. He practiced in all branches of law, his favorite being constitutional law. He appeared for and against most of the government undertakings. He is a person of high integrity and sturdy independence. He is known for his able advocacy and sound knowledge of the fundamentals of law. He is large-hearted and has helped several people. He was closely associated with Salaha and Cheyuta, NGOs educating and fighting for the rights of the landless poor and marginal farmers. He has ably defended the cause of tribals, Dalits, and children from vulnerable sections of the society. He is liberal in his outlook and believes in finding solutions to problems by negotiation, dialogue, and debate. He was appointed Advocate General of the State of Andhra Pradesh in 2005 and served as AG till 2009. He is passionate about constitutional rights, more particularly individual freedom and associated rights. I am sure you will find these for yourself when you listen to him today. Thank you.
Thank you, Sridhar. May I now request Justice Raghuram to say a few words about my father and then after that to conduct the proceedings. Thank you so much.
Alladi Sitaram, Annapurna, Uma, Sridhar, members of the extended and immediate Alladi family, distinguished and revered my seniors, judges, my colleagues with whom I worked, distinguished members of the legal profession, and other distinguished members of the audience, and my dear friend, former Advocate General Mr. C.V. Mohan Reddy. I must apologize for the not very brief bio that Uma read out. Normally, this recitation of biodatas are usually hagiographic, and one would like to meet oneself when one is introduced. So effulgent is the commendation, often not very well deserved. My only justification perhaps for being here to preside over this function is that I am an adopted member of the Alladi family. Late Justice Alladi Kuppuswamy, as Uma has said, always treated me as his grandson. I was his junior's junior. I have very fond and vivid memories of Justice Kuppuswamy Garu. I first met him in 1979, shortly after I joined the chambers of my senior Mr. Venkatramanaya, who later became the Advocate General for the then composite of state of Andhra Pradesh, a position he held on more than one occasion. Justice Kuppuswamy retired as the Chief Justice of the composite state in March 1982. And thereafter, I had the privilege of meeting him on more frequent occasions. A cherished association which continued till the end in 2012. Justice Kuppuswamy's court I had, as a peonage, when he was a peonage judge, I didn't have many occasions to be in his court because my senior, being his junior, wouldn't appear in his court. But when he became a Chief Justice, he used to appear whenever he was appearing for some institutions, not in a private brief. And even otherwise, we used to sit in his court because in those days, unlike later, important and complex issues used to gravitate to the Chief Justice's court. And nowadays, it's slightly different or substantially different. Justice Kuppuswamy was patience and calm personified. There was humor, there was patience, there was calming of ruffled feathers, and above all, subtle but pertinent signal to members of the bar that generation of light and not sound is the calling of the legal profession. Today, adroitness at the bar is measured in decibel levels. More so in Delhi, where South is a much more sedate place. When I went to the tribunal, for a week I was banged. Loud decibel levels, I was in a tax tribunal, therefore the value of the litigation was high. And if the value is high, the professional fees is high. Professional fees is high, it has to be justified in decibel levels. And repeating oneself ad nauseum So after a week I told him, I'm an old bandicoot, I've heard this all. And therefore, when you tire down, when you are shout yourself hoarse, then I'll start hearing you on merits. After a week, things changed for the better. There's one instance I heard, and this is not, it is real incident that I heard, of Justice Kuppuswamy's stewardship of the court as the Chief Justice. An instance that underlines an important attribute of leadership. Apparently, there were acrimonious exchanges during court proceedings between a lawyer and a learned single judge. The acrimony led to the lawyer and the judge issuing contempt notices to each other. Both thereafter met Chief Justice Kuppuswamy separately to convey the respective narratives of the incident and seek his intervention. Chief Justice Kuppuswamy appears to have told both, and I heard it from one of them, that they should have met him before the matter regressed to the stage of issuing notices of contempt. And now that they had exchanged pleasantries, there was no role for the Chief Justice. Later on the advice of the Chief Justice, other judges and senior members of the bar, the matter concluded amicably, with both expressing in the open court contrition at the avoidable exchanges during the heat of the moment, and the notices were withdrawn. This should serve as a lesson to many a judge, particularly in the present days when there's more physicality in the court and higher decibel levels usually exchanged. I used to visit Justice Kuppuswamy frequently after his retirement in 1982, either on the way back from the court or later in the evening when the work at the senior's office was over early. And I cherished and savored the warmth, the hospitality, and the wise mentorship of his company. I must mention the affection showered on me by Mrs. Lakshmi, Justice Kuppuswamy's wife, who always treated me and all members of my family with deep love and as part of the immediate family, along with son Sitaram, his wife Annapurna, and daughter Uma. I distinctly remember the very intimacy and warmth that Justice Kuppuswamy and Lakshmi Garu used to enjoy, particularly when they were sitting in front of the television enjoying a cricket match. Each would support one of the groups. They would have acrimonious debates as to who would win. And often Lakshmi Garu used to get more agitated if Kuppuswamy Garu's team won, which is occasionally the case. Justice Kuppuswamy was ever in touch with evolving trends in law and the patterns in judgments, particularly those dealing with constitutional law and judicial review. He was concerned about the exponential regression in our democratic fabric. These are his words: expansion and intrusion of the judicial process in unwarranted areas of administration. He once observed, and I was a witness to that observation he shared with some other senior lawyer, that we constituted ourselves into a society under law, but it is slowly transforming into a nation under lawyers. This problematic, the dilemma of jurisdictional choice, if you will, continues and exponentially so. There is some sort of institutional imperialism by the three branches who try to overrun the other branches. And judiciary sometimes, some judges in the branch sometimes delude themselves that they are a one-stop port of call for all that ails the society, a broad-spectrum antibiotic, if you will. And I have seen some judges who believe that the country should be saved from the people. That's quite a leap of delusion, if you will. I had fewer occasions while a lawyer to study the judgments of Kuppuswamy Garu in civil and commercial law areas, but had greater opportunity to do so when I served as a judge. Regardless of the branch of law involved, I noticed that he dealt with appreciation of facts involved and the legal principles with precision, meticulous attention to detail, and his craftsmanship in drafting judgments was flawless, the narrative simple, and the outcome wholesome. That was not my trait, and he often used to tell me that my language was too complicated. In the area of public law adjudication, particularly interpretation of the Constitution, and navigating the nebulous boundaries of judicial review, he was a liberal who cherished the values of dialogue and dissent in society, abhorred obscurantism. He was critical of including a study in astrology in a university curriculum. He believed that society is polychromatic and not a singularity. Justice Kuppuswamy professed and adopted in his judicial disposition a deep fidelity to the separation of powers principle, to the legitimacy of democratic choice, even apparently unwise choices. He adhered to the timeless verity that constitutional and legislative texts do matter, now they increasingly matter less, that judicial independence does not mean independence from the law, and that judicial branch is not a one-stop port of call for alleviation of all problems of the society. He was a conservative jurist, a fast-vanishing species. Long after his retirement, until the very end of his long and fruitful life, Justice Kuppuswamy kept abreast of the developments in law, literature, and current affairs. He was intimately and actively associated with several social organizations engaged in the study and propagation of Sanskrit and Telugu literature, including Acharyakul, an organization founded by Vinoba Bhave, with Sarvodaya Vidyalaya, an organization engaged in imparting education to slum children, with Surabharati Samiti, an institution formed for propagating Sanskrit, and served as the chair of the Board of Trustees of the Association for the Care of the Aged. Among several enduring legacies endowed for posterity by Justice Kuppuswamy, some deserve special mention. He founded the Alladi Memorial Trust in memory of his distinguished father to help indigent lawyers, litigants, and students of law, and catalyze the administration of justice. Under the auspices of this trust, annual Alladi Memorial Lectures are organized, and distinguished jurists speak on important legal issues, especially constitutional law. The AV Memorial Trust was also established in memory of his revered mother to support medical assistance for the poor. Main's Hindu law, a standard commentary on this branch of law, was revised by Justice Kuppuswamy and published in 1986 after more than 35 years of an earlier revised edition of this celebrated work, and is considered a standard reference text on this subject. Lawyer Chalameshwar, who later became Justice Chalameshwar of the Supreme Court, was also associated with the revision of Main's Hindu law. Firmly convinced that ethical and moral values are becoming increasingly episodic in contemporaneous society, and that these must be inculcated from childhood, Justice Kuppuswamy authored brief accounts of the Ramayana, Bhagavata, and Mahabharata intended for young persons. Son of the legendary lawyer, Advocate General for the State of Madras, and a member of the drafting committee of the Constituent Assembly, Alladi Krishnaswamy, hired by our dear Tamil cousins, and son-in-law of that eminent Judge Uma Maheswaram Garu, Justice Kuppuswamy inherited steep challenges to fame and success. He navigated these challenges with dedication, sustained hard work, ethics, and discipline of a very high order, and lived up to the genetic reputation of achievers. His son Sitaram and daughter Uma have equally distinguished themselves in the areas and careers of their choice and nurtured the values of the iconic father, believed in and followed throughout his long life. Kuppuswamy was a Sahasra Masa Jivi, lived 1,000 moons and more. On this memorable occasion, as we celebrate and cherish the 101st year of his birth, I offer my deepest salutations to the revered memory of Justice Alladi Kuppuswamy. I now invite Senior Advocate and former Advocate General Mr. C.V. Mohan Reddy to deliver his address. I think it's customary to have a Q&A after this. Is that so? Do we have a Q&A after the question and answers? Yeah. Yeah.
President of today's function, Justice Raghuram, was Raghu to me, and Justice Jagannath Rao, former judge of the Supreme Court, and other judges of the High Court, and members of the family of Alladi family. When I was approached sometime in 2000 by Professor Uma, she called me and wanted an appointment with me. I didn't expect that I was getting into this. I tried to persuade her to find some other speaker, and I also suggested that I'll give a few names who are more accomplished than me, and intellectuals with great learning and wisdom and experience would eminently fit the bill. But she ultimately succeeded in persuading me. And now I came to know that it was Mr. Manohar who was responsible for this. When I accepted this invitation with great reluctance, I was aware that I have rushed in where angels fear to tread. Addressing a gathering of intellectuals, gathering of learned people, is always a difficult task. I only hope at the end of the speech, I would have, you people would be leaving this hall with agitated minds, as Professor Uma put it, and that should be the objective of the lecture. By the time I entered the legal profession sometime in 1978, let's say Alladi Kuppuswamy is already a senior judge heading a bench. Those days, for people like me who were young in the profession, were juniors, appearing before a division bench was practically out of question. We would not get an opportunity, not even for asking for a passover. There would be other seniors in the office who would be interested with the job. Our job was to go and watch the proceedings sometimes, sit in the court and observe what's happening. It was only on a Friday that when judges sit single, because on Fridays all the judges sit single dealing with the matters that come from their respective administrative districts, that juniors would get an opportunity to sometimes of their own cases, which I didn't have for about 4 to 5 years after entering my profession. Our senior would throw a bundle at the junior and say, okay, go and appear and see. That would probably be one of the worst cases in the office that the senior would hand over, because he knows that the case anyway is a lost cause. Therefore, he would entrust the matter to the junior. On one such occasion, my senior threw a file at me at about a few minutes before the matter was to be taken up, and told me that this is a land ceiling case arising under the AP Agriculture Land Ceiling Act. Go and tell the court that this is a land ceiling case. He would automatically admit and grant a stay, because that was what was happening those days. All land ceiling matters would get automatically admitted, and without really examining the scope and the ambit of the revisional jurisdiction under the relevant provision of the Act. So I went into the court. So I said, my lord, this is a land sealing case, and kept quiet. So he asked me, so what? Under which provision of law is it filed? Then I didn't have answers for a few questions that he posed. Justice Kuppuswamy was known by then, he had the reputation of being a very kind judge, kind to the juniors, advising them sometimes as to how to go about the matters. So he told me, you are in a revisional jurisdiction. Revisional jurisdiction has very limited scope, that two concurrent findings. Therefore, I'll take up the matter in the afternoon session, go through the facts of the case and argue the matter in the afternoon. So I had to then go through the file, understand the facts of the case. Then in the afternoon session, he admitted the matter and granted an interim order, stay of all further proceedings, like surrender of the lands, etc. And even now I am sure that it was not because of my persuasion or my ability to put forward a case before the learned judge and make him admit the case. It was sheer sympathy jurisdiction of the learned judge that made him admit it. In order to encourage me, probably I don't know why he took it, why he did that. He was a kind judge, so I think his kindness prevailed over the legalities at that point of time when he admitted the matter. After retirement of Chief Justice Kuppuswamy, I had an opportunity to appear in 2 or 3 arbitration matters before him. Arbitration matters are generally very informal in nature, so I had an opportunity of interacting more with him other than the case before him. It was a learning experience appearing before Justice Kuppuswamy. He would guide the advocates. He would point out these are the aspects of the matter that need to be projected, that need to be argued. I then realized, because till then I only heard about his in-depth knowledge, scholarship of law, and his humility, etc. But I could personally perceive these aspects when I had this association with him in those 2-3 matters for about 1.5 years or 2 years occasionally. I pay homage to Justice Kuppuswamy, Chief Justice Kuppuswamy, on this occasion. The topic for today's lecture, Democracy, Dissent and Constitution of India, is, all of you are aware, is of topical interest. In fact, I think Mr. Sitaram was saying that it's hot topic. Justice T.N.C. Rangarajan was saying that it's hot topic. And I felt it's relevant when I was asked to choose the subject. I thought it's the most relevant subject now in the present context, having regard to the political scenario that we see, having regard to the things that are happening, not only by the state, actions taken by the state, but between various sections of the society. I felt it's relevant in today's times with elected governments headed by political parties of all hues and colors all over the country, elected though through a democratic process, people exercising their free will, notwithstanding the role of money, caste and other factors, frowning upon and suppressing criticism, dissent, expression of contrarian opinions, and opposing policies of the government and opposing policies of the government, ignoring the fact that they themselves were victims of such intolerance when they were not in power, and protested rather vehemently against such high-handed conduct. You will find this conduct amongst the politicians. When they are out of power, they think that they have all the freedom to do anything and say anything they like. But then when they get into the power, everything that's said that's critical of them or their functioning is treated as, and is sought to be now, in the last few years, brought within the scope of some provision of the IPC or the other, so that the person who is accused of such an offense will go around the courts for the next 4 years, 5 years, or 7 years, or 10 years, being the criminal justice system being what it is. We all, as lawyers, know that how long it takes for a person who is accused of an offense under IPC or any of other laws where free speech is sought to be regulated. We'll have to go to the court maybe a few hundred times, appear in person there, and then ultimately is acquitted. So that's how the power is being misused to suppress free speech. The word democracy is derived from the Greek word demokratia. Demos means people, and kratia meaning rule. In 1863, Abraham Lincoln, the 16th President of the United States of America, captured the essence of democracy in his famous Gettysburg Address as government of people, by the people, and for the people. But most of the persons in power seems to believe that it's government of them, for them, and by them. So this speech of the Abraham Lincoln is given a different meaning altogether. Preamble to the Constitution of India declares that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. This declaration in the preamble forms the basis for the governance of this country and the following provisions contained in the Constitution. India, having unshackled itself from the colonial rule and after becoming a republic, chose deliberately a path of parliamentary democracy through the Constitution of India, giving universal franchise to every adult citizen in the country. Notwithstanding the fact that 80% of the people of the population at that time, or voting population at that time, was illiterate, and there were many doomsday predictors in the polity itself at that point of time, that who had expressed grave doubts about the success of democracy, having regard to the fact that universal franchise is given to the people of the country, coupled with the fact that 80% of the people were illiterate. They did not believe that these doomsdayers did not believe that these illiterate persons could make a choice, an informed choice as to who should rule the country or who should rule them, who should rule the country. However, time and again, the citizens of this great nation have shown to the world that they have embraced democracy in no uncertain terms and have thrown out of power entrenched political parties. However, we cannot ignore or forget the hiatus in this democratic process when internal emergency was imposed and fundamental rights were suspended. That was the dark era for the democracy and the Constitution. However, after the emergency was lifted, people exercising their free will throughout the party which had imposed emergency. Now, democracy is well entrenched in this country and vibrant and firmly established, notwithstanding the fact that there are many aberrations, there are many lacunae, there are many factors which should not influence people in a democratic country, but they do because of the plurality of the society, because of the divisions in the society, and the advantage that's being taken by the politicians. However, that does not mean that we can remain complacent, as attempts are made and are being made constantly to throttle dissent, which is the very essence of democracy. Suppressing freedom of speech and freedom to assemble peacefully by invoking police power of the state. I would quote here French philosopher Voltaire, who said that I wholly disapprove of what you say, but I will defend to the death your right to say it. And that's missing in this country. Our persons in power seem to say that I don't approve what you say, so you go to jail. Not that he will defend it till the end of his life. Voltaire was indeed a champion of free speech and the free-flowing political discourse. He seems to have said this in the context of a publication by another French philosopher who in 1758 wrote a controversial work titled De la Spirit. This book was condemned in the French Parliament and in other public fora in France, apart from being burnt on the streets of Paris. Voltaire, though did not agree with the ideas propounded by this philosopher, whose book was burnt on the streets of Paris, nonetheless believed that this author, whose book was condemned, has a right to free speech and has a right to express what he thought was the truth. Dissent is the essence of democracy. Every society is governed by rules of conduct, moral, religious, ethical, which have evolved over a long period of time. However, when new thoughts are projected by thinkers, philosophers, reformists, disagreeing with the well-trenched norms and mores, there will be resistance and sometimes violent reaction. These days we see only violent reaction, not resistance. Resistance I can understand to some extent because somebody is trying to say something which you firmly believe in, you try to resist it for some time, argue out, and then maybe you get convinced or you don't get convinced, leave it. But then these days it seems to be every statement that's not liked by the authority or the person, that persons in power seems to result in violent reaction. Sometimes by the state and sometimes by the entrenched groups in the society, ignoring that if the society does not give space for the new thoughts to flourish and the new paths to be trodden, the society will become moribund and horizons of the mind will not expand. We would not have had a Buddha, Mahavira, Jesus Christ, Prophet Muhammad, Guru Nanak Dev, Martin Luther, Rajaram Manohar Rai, and nearer home, Kandukuri Videslingam, all of whose thoughts and philosophy they propagated challenged the existing perceptions of religion and social mores. The society would have been, without these thinkers and philosophers, would have been as it was maybe 300 years back, 400 years back. The society develops because there are new thoughts that come to the fore. The new philosophy that's propagated because the existing philosophies has become moribund. And in the thinking of this particular philosopher who is espousing a new philosophy or a new thinking. The existing philosophies must change. Unless that happens, the society would not progress. There can be no democracy without dissent. Any country which suppresses dissent would be a totalitarian state. The blanket labeling of dissent as anti-national or anti-democratic strikes at the very root of our commitment to protect constitutional values and promotion of a deliberative society. Democracy without dissent is like the silence of a graveyard. Dissent has different facets. Dissenting is inherent in every human being. We keep dissenting with everybody. I think when I was young, my father would say, don't do this. My father would say, do this. I would not agree with it. So that's also dissent, in a sense. In everyday's life, we come across various expressions of dissent in our personal relationships, in the use of public spaces, etc. I am in this lecture not concerned with such dissents. I will mainly deal with the political dissent without which we cannot consider ourselves to be a democratic society, and attempts to suppress the same, and the role and duty of the constitutional courts in protecting dissent. A democracy welded to the ideal of reason and deliberation ensures that minority opinions are not strangulated, and ensures that every outcome is not the result merely of numbers, but of shared consensus, where on the one hand, due deliberation and consideration within the institutional spaces underlines a commitment to democracy. Deliberation by individuals in public spaces, on the other hand, is of equal, if not of more importance. The true test of democracy is its ability to ensure the creation and protection of spaces where every individual can voice opinion without fear of retribution. Inherent in the liberal promise of the Constitution is a commitment to plurality of opinions. However, the litmus test of any claim of commitment to deliberation is assessed by the response of two key actors, the state and other individuals. If you wish to deliberate, you must be willing to hear all the sides of the story. A legitimate government committed to dialogue does not seek to restrict political contestation but welcomes it. But we see these days, on the other hand, the converse of it. Political establishments do not seem to enjoy any contestation, any expression of contrary opinion. Instead of welcoming such expressions of dissent, such expression of contestation, expression of contrarian opinions, efforts are made to suppress. A state committed to the rule of law ensures that the state apparatus is not employed to curb legitimate and peaceful protest, but to create spaces conducive for deliberation. Within the bounds of law, liberal democracies ensure that their citizens enjoy the right to express their views in a very conceivable manner, including the right to protest and express dissent against prevailing laws or proposed changes in the legislation. Protecting dissent is but a reminder that while democratically elected governments offer us a legitimate tool for development and social coordination, they can never claim a monopoly over the values and identities that define our society. The employment of state machinery to curb dissent instills fear and creates a chilling atmosphere on free speech, which violates the rule of law and detracts from the constitutional vision of a pluralist society. The restriction of spaces for questions and dissent destroys the basis of all growth, political, economic, cultural, and social, as well as the premise on which our Constitution is founded, that is, preamble to the Constitution. In this sense, dissent is the safety valve of democracy. The silencing of dissent and the generation of fear in the minds of people goes beyond the violation of personal liberty and a commitment to constitutional values. It strikes at the heart of dialogue-based democratic society, which accords to every individual equal respect and consideration. A commitment to pluralism requires positive action in the form of social arrangements, where the goal is to incorporate difference, coexist with it, allow it a share of social space. There is thus a positive obligation on the state to ensure the deployment of its machinery to protect the freedom of expression within the bounds of law and dismantle any attempt by individuals or other actors to instill fear and chill free speech. This includes not just protecting free speech, but actively welcoming it and encouraging it. An equal obligation to thwart attempts to curtail diverse opinion rests on every individual who may not agree with opposing views. Mutual respect and the protection of a space for divergent opinions is the process of viewing every individual as an equal member of a shared political community where membership is not premised on sharing a unanimous opinion. When we look at each other, we do not just see fellow citizens entitled to our individual liberties. We perceive a mind and consciousness which is not our own, which has its own view of the world and its own account of how it should treat people who it sees as the other. Taking democracy seriously requires us to respond respectfully to the intelligence of others and participate vigorously, but as an equal in determining how we should live together. Democracy then is judged not just by the institutions that formally exist, but by the extent to which different voices from different sections of the people can actually be heard, respected, accounted for, and are allowed to be heard and respected by the institutions. The great threat to democracy is the suppression of difference and silencing of people and unpopular voices, offering alternate or opposing views. Suppression of intellect is the suppression of the conscience of the nation. An author says, David S. Clarke says that suppression of intellect is the suppression of the conscience of the nation. Rule of majority is an integral part of democracy, but majoritarianism is the antithesis of democracy. In a democracy like ours, where we have elections based on first past the poll principle, the government in most cases does not represent the majority of the population, and often not even the voting electorate. Therefore, when those in power claim that they represent the will of all the people, that's more often than a totally baseless claim. They may be the elected government voted on the first past the post system by a large number of voters, but it cannot be said that they represent the entire will of people. Even assuming that they represent more than 50% of the electorate, can it be said that the remaining 49% of the population has no voice in running the government? Can it be urged that the remaining 49% cannot speak for the next 5 years till the elections are held? Should these 49% be totally ignored if they oppose what is said by the government? In my view, the answer is a big no. The right to dissent is one of the most important rights guaranteed by our Constitution. As long as a person does not break the law or encourage strife, he has a right to differ from every other citizen and those in power and propagate what he believes is his belief. The superior courts, as protectors of the rights of people, have a duty to ensure that the powers that be do not suppress dissent, because that will have, to use the words of Justice Norman, a chilling effect on the freedom of speech. In quoting a passage from Shreya Singhal's case where the Lordships have struck down Section 66 of the Information Technology Act, in point of fact, Section 66A is cast so widely that virtually any opinion on any subject would be covered by it, as any serious opinion dissenting with the mores of the day would be caught within its net. Such is the reach of the section and if it is to withstand the test of constitutionality, the chilling effect on the free speech would be total. In a country governed by rule of law, rule of law and democracy, dissent represents an external form of power balance between the government and its citizens, and thus forms part of what is described as a civil society and political activism. Dissent helps to make the subject of political dissent from periphery into the center of politics. The liberal democratic rule of law accommodates regulation of dissent and provides an institutional framework for dissenting views. That's what our Constitution does by guaranteeing right to free speech under Article 19(1)(a). Then I'll go to the Constitution and the dissent. Dissent is integral to democratic process. Similarly, freedom of speech and experience is an inalienable right, and the Constitution confers the same on citizens of this country under Article 19(1)(a) of the Constitution of India. Of course, this right conferred on the citizens is circumscribed by the limitations imposed under Article 19(2). Integral to the freedom of speech is the right to assemble peacefully, without arms, guaranteed under Article 19(1)(b), and the right to form associations guaranteed under Article 19(1)(c), and the right to move freely throughout the territory of India under Article 19(1)(d). The rights guaranteed under Article 19(1)(a), b, c, and d are not absolute and are conditional, subject to limitations imposed under Article 19(2), 3, 4, 5, subclauses 2, 3, 4, and 5, interdependent and intertwined with each other. As explained by C.Y., the great jurist, in his treatise on Constitution of India, the rights represent the claims of the individual. The limitations protect the claims of other individuals and the claims of the society or the state. To say that the rights are fundamental and the limitations are not is to destroy the balance which Article 19 was designed to achieve. To say this is not to belittle the fundamental rights, but only to say that the rights are not absolute and can be enjoyed only in an orderly society. The extent of rights guaranteed under Article 19(1) and the limitations that could be imposed on them, a subject matter of discussion and debate in the Constituent Assembly, and was finally adopted in 1949. Even before the ink dried on the parchment, the first attack on the right guaranteed under Article 19(1)(a) came in the form of a ban on the entry and circulation of weekly magazine called Crossroads, printed and published by Ramesh Thapar in Bombay, critical of the government policies. This ban was imposed by the government of Madras under an existing law. The ban was challenged by Mr. Ramesh Thapar on the ground that it was violative of Article 19(a) right, and also challenged the validity of the Act invoking such provisions. Ban was imposed. A 7-member Constitution bench of the Supreme Court upheld the challenge and struck down both the notification banning the magazine and the Act under which it was issued, holding that under the law restricting the freedom of speech and expression is directed solely against undermining the security of the state and overthrow of it. Such law cannot fall within the reservation under Article 19(2) of the Constitution. 19(2) as it stood prior to amendment, first amendment to the Constitution, contemplated only two, apart from two other like defamation and protection to the courts by way of contempt of courts. The contempt, speeches amounting to contempt and defamation. Apart from these two, there are two other constraints which were imposed, either security of state or security of state was the only constraint that was imposed at that point of time. The Supreme Court found that the ban imposed by the government of Madras, did not relate to the security of state. Therefore, struck down both the notification. The act which enabled the government to impose such a ban was also struck down as unconstitutional. On the very same day came the judgment of the Supreme Court in Disbhushan versus State of Delhi, in which authorities sought to impose pre-censorship on a magazine called Organizer, requiring them to place all the material pertaining to certain aspects of society to be placed before the authorities for their scrutiny before the publication in the newspaper. This was challenged in the Supreme Court. Following the decision, Ramesh Thapa, Supreme Court held that the imposition of pre-censorship on a newspaper is a restriction on the liberty of press, which is an integral part of freedom of speech and expression. Then came the First Amendment to the Constitution of India, substituting the original Article 19(2), expanding the scope of restrictions on the exercise of freedom of speech and expression. Pausing here a minute, I found an article where a letter written by the then Home Minister Sardar Patel was extracted. Sardar Patel wrote to Jawaharlal Nehru, stating that these two judgments have taken away the basis for all the. This is what Sardar Vallabhbhai Patel wrote to the Prime Minister in July. The judgment came in the month of May. Says that crossroads and organizer rulings have knocked the bottom out of most of our penal laws for control and regulation of press. This is the mindset of the people in power, even at that point of time. Patel, who fought for freedom, is known as the strong man of the strong man of the country at that time. Was also not, could not bear the criticism of the policies of the government. So he felt that these two judgments have taken away the foundation or the basis for most of the penal laws contained in IPC, which itself was a colonial law, and felt that they are required to be changed because we would not be able to control the press. By saying we would not be able to control the press, what you are trying to do is control the freedom of speech, control freedom of expression, control your right to dissent. I'm trying to point out that this is not a new phenomenon that's now come into the politics. It's been there as early as in 1951. However, while expanding the scope of restrictions on the exercise of freedom of speech and expression, an important feature of amended clause is the inclusion of reasonable restrictions, whereas in the pre-amended Article 19(2), there was no mention of reasonable restrictions. Now it's mentioned that there should be reasonable restrictions. After this judgment, Madras government declared a society known as People's Education Society as an unlawful association under the Madras Criminal Law Amendment Act 1950. This order of the Madras government was quashed by the Madras High Court, and the Supreme Court, while affirming the judgment of Madras High Court, indicated the test of reasonableness. Both the substantive and the procedural aspects of the impugned restrictive law should be examined from the point of view of reasonableness. That is to say, the court should consider not only factors such as duration and the extent of restriction, but also the circumstances under which and the manner in which their imposition has been authorized. It's important in this context to bear in mind that the test of reasonableness, wherever, I'm quoting from the judgment, wherever prescribed, should be applied to each individual statute impugned, and no abstract standard or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. in evaluating such elusive factors and forming their own conception of what is reasonable in all circumstances of a given case, it is inevitable that social philosophy and the scale of values of the judges participating in the decision should play an important part, and the limit to their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint, and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorizing the imposition of the restrictions, consider them to be reasonable. This last sentence may not be true now, but those days I think the learned judges felt that that should be the respect that should be given to the parliament, even though, of course, this principle remains that a law is considered to be valid unless it's struck down by the court, a law properly made by a legislature or parliament. A further amendment to Article 19(2), adding an additional ground, that's the sovereignty and integrity of the state, was made by way of 16th Constitutional Amendment Act. It has been held by the Honorable Apex Court that the restrictions envisaged under Article 19(2) to 6 on the fundamental rights guaranteed under Article 19(a) to (g) are exhaustive, and neither the courts nor the executive can create any further exceptions to the guaranteed rights than what are envisaged under the Constitution. India is a plural society with diverse languages and religion. How do we as the people and the state sustain this pluralism and multiple culturalism is a big question that looms large. Integral to and indispensable to the right of freedom of speech is the right of individuals to disseminate information and ideals, and the concomitant right of a citizen to receive ideas and information that's protected in Article 19(1)(a), that the citizen wishes to hear. You can't impose yourself on the basis that you have a right to free speech, therefore can speak anything and impose your thoughts and your ideas on some other person. He also has his own idea, he has his mind, you will have to listen to him. If you are not prepared to listen to him, you have no right to impose yourself on that person. Therefore, the right to communicate and receive ideas, facts, knowledge, information, beliefs, theories, creative and emotive impulses by speech or by written word, drama, theatre, dance, music, film, through a newspaper, magazine or book is an essential component of the protected right and may be exercised untrammeled by unreasonable restraint. This is from the judgment of Mr. Raghuram, Justice Raghuram, in Da Vinci case. The three matters that Professor Uma referred, that's religious reservation and right under 19(1), and another aspect which Professor Uma referred to is some of the leading judgments of Raghu. I have had the misfortune of appearing for the respondent, for the state, and I had to suffer the result. I wouldn't say anything. And, of course, in the Da Vinci case, I was asked to appear by the state, by the CM. And I told him that it's impossible to defend this, and anyway, I personally don't believe that we have a right to impose such a restriction. I asked him to excuse myself from appearing in that case, and Mr. Rajshekar, late Rajshekar, agreed for that. The government leader argued the matter. It's a classic on 19(1) right by Justice Raghuram. Freedom of speech and expression and constitutionally legitimate restraint upon it is an area bristling with considerable complexity and susceptible to several diverse normative assumptions. Competing values and conflicts permeate the area. This is again from the same judgment, quoting Raghuram. However, since in the constitutional context, Article 19(1)(a), it is the freedom of speech and expression which is guaranteed, and not the state's right to impose restrictions thereupon, Even categories of speech and expression which might enjoy less than the full conspectus of constitutional protection must be subject to rational analysis, and a challenged state action impacting the guaranteed right must be strictly scrutinized to test A, whether it falls within permissible area of restriction, B, whether the restriction is reasonable, C, whether there are available less restrictive alternatives that the state ought to have pursued before resorting to the impugned action. Earlier in this analysis, it's considered that the freedom of speech and expression is an inalienable component in the fulfillment of rational human personality. Intrinsic to such fulfillment is the right of an individual to be informed about facts, ideas, theories about scientific, historical, technological, social, political, religious and cultural developments, about competing, even combative doctrines, theories and viewpoints on religious, social, political institutions and the personalities which influence these institutions. The right to be informed not only about the orthodoxy and dogma, but also about heterodoxy and counter-dogma as well. The choice of what information to receive is a protected individual choice, subject to state control and regulation only for compelling governmental purposes within the defined spectrum of purposes qua the Article 19.2. Freedom of speech and expression discourse in the Article 19 context must therefore accommodate the right to know, the right not to know, the right of open-minded liberal and curious individuals as well of members of closed communities and cultures. While considering the reasonableness of a state-imposed restraint, it is therefore inevitable that the reason for the restraint, its legitimacy in the context of the protected freedom and the permissible area of its invasion by the state, and whether the state could have employed less restrictive alternatives of restraint must all be considered while considering a restriction imposed by the state on the right to freedom of speech. We live in an information communication obsessed period of human civilization. Contemporaneous man is therefore subject to voluminous and diverse printed and audio-visual material. Such material may be obnoxious, may constitute a visual clutter, may offend one's sensibilities, fundamental assumptions of faith or of social and political institutions, or may also be offensive to deeply held beliefs. The question therefore arises, a question that goes to the heart of the discourse as to freedom of speech and expression, whether an individual's freedom may be exercised only when there is universal approbation of the content of the speech and expression. If one has to express oneself expecting universal approbation, then it will not be a dissent at all. A dissent is something where there will be at least some people who would not agree with you, or sometimes even majority of the people may not agree with you, or the entrenched Moors may not agree with you, persons may not agree with you. Quotes since the freedom to speak and express and its corollary, the right to knowledge and information, includes the freedom to be protected from speech, expression and information that an individual does not desire to expose himself to. The problem is one of accommodation of these corollary and competing values which are in a way complementary, though apparently in conflict. Courts in other jurisdictions have grappled with this balancing act. With Justice Raghuram in Da Vinci case. In Raj Kapoor and others versus so-and-so, Justice V.R. Krishna Iyer, speaking for the court dealing with the pro bono publico prosecution against the producer, actor and other connected with the film Satyam Shivam Sundaram on the ground of prurience and obscenity, observed the world's greatest paintings, sculptures, songs, dances, India's lustrous heritage, the Konaraka, the Khajurahos, lofty epics, vicious in patches, may be asphyxiated by law if prudes and prigs and state moralists prescribe paradigms and proscribe heterodoxies. Our commitment of freedom of expression demands that it cannot be suppressed unless situations created by allowing the freedom are pressing and the community interest is endangered. The anticipated danger should not be remote, conjectural or far-fetched. It should have proximate and direct nexus with the expression. The expression of thought should be intrinsically dangerous to the public interest. In other words, the expression should be inseparably locked up with the action contemplated, like the equivalent of a spark in a power keg. The Constitutional Bench of Supreme Court in a recent judgment considered the question whether the additional restrictions could be imposed on one fundamental right by invoking the other fundamental right. The Supreme Court had said no. One of the arguments raised in this behalf in the state was, this is referring to Sakal newspapers, in which there was a challenge to a notification issued by the Union of India prescribing the price of the newspaper, having regard to the number of pages that a newspaper can carry. So there was a restriction on the price as well as the number of pages that a newspaper can have. This was when it was challenged by Sakal newspapers, which is a newspaper published from Mumbai, a Marathi newspaper. The challenge was resisted by the Union of India on the ground that we are not touching the freedom of speech. They are entitled to speak anything, say anything within the bounds of law. We are controlling it by way of 19(1)(g), which gives a right of freedom of trade, where we have a right under 19(1)(6) to control. Is a reasonable restriction within the view, because the newsprint is in scarcity, so we have to import it, we have to save foreign currency, balance of reserves, and therefore this condition was imposed. Supreme Court repulsed it, saying that it's a direct attack on the freedom of speech. When you prevent a newspaper from printing the more than the number of papers that are prescribed under this notification, you're directly attacking the freedom of speech that's enshrined in the Constitution and given to the newspapers. One of the arguments raised on behalf of the state in the said case was that there are two aspects to the activities of a newspaper, namely the dissemination of news and views, and two, the commercial aspects. While former would fall under 19(1)(a), the latter would fall under 19(1)(g), that's the business part of it, where they make money by publishing advertisements. In Sakal, the challenge was to an order of central government restricting the number of pages of a newspaper that a newspaper can print and the prices that could be charged. Since the two rights are independent and since the restrictions on the right under 19(1)(g) can be placed in the interest of general public under 19(6), it was contended by the state that the orders are saved by Article 19(6). But the said argument of the state was rejected by the Constitutional Bench in Sakal papers, and in the following verse: if a law directly affecting it, a right guaranteed under Article 19, is challenged, it is no answer that the restriction enacted by it are justifiable under clauses 3 to 6. For the scheme of Article 19 is to enumerate different freedoms separately and then to specify the extent of restrictions to which they may be subjected to and the objects for securing which this could be done. The citizen is entitled to enjoy each and every one of the freedoms together, and Clause 1 does not prefer any one freedom to the other. That is the plain meaning of this clause. It follows from this that the state cannot make a law which directly restricts one freedom even for securing the better enjoyment of another freedom. All the greater reason, therefore, for holding that the state cannot directly restrict one freedom by placing an otherwise permissible restriction on another freedom. Fraternity, finding its space in the preamble, is an emphatic reiteration of the Constitution that survival of all fundamental rights and the survival of democracy itself depends upon mutual respect, accommodation and willingness to coexist in peace and tranquility on the part of the citizen. The Supreme Court has several occasions struck a balance between the competing fundamental rights and placed a particular fundamental right on a higher pedestal than the other, depending on the object sought to be achieved. Fundamental rights guaranteed under Article 19(1)(a) of the Constitution is restricted under many statutes, more particularly the Indian Penal Code. there are two types of restrictions. Now I am coming to the present scenario. Fundamental rights guaranteed under Article 19(1)(a), right guaranteed under Article 19(1)(a) of the Constitution is restricted under many statutes, more particularly under the Indian Penal Code. There are two types of restrictions under the IPC. One traceable to Article 19(2) and the other to protect a person or a class of persons whose rights are protected under the other provisions of the Constitution. I will not venture into enumerating these provisions. However, suffice it to say that these provisions of the IPC that are particularly traceable to Article 19(2) restrictions are increasingly being used by the state to stifle freedom of expression and propagation of one's belief. Having regard to the criminal justice system in the country, it is essential that these actions by the state, mostly at the instance of individuals, motivated by political considerations, have chilling effect, as succinctly explained in Shreya's single judgment. Of late, there has been an increasing tendency to invoke Section 124 of the Indian Penal Code by the governments, both of central as well as state. Section 124(a) of the Indian Penal Code deals with sedition. When it was sought to be included as one of the restraints on the freedom of speech in the Constitution, in Article 19(2), it was opposed vehemently by the members of the Constituent Assembly. K. Munshi argued that there is no room for the sedition in India and stated thus, I quote, "Now that we have a democratic government, a line must be drawn between criticism of the government, which should be welcome, and incitement, which should undermine the security or order on which civilized life is based, or which is calculated to overthrow the government as a matter of fact. The essence of democracy is the criticism of the government." Another member said that suppression of lawful and peaceful opposition would lead the country towards fascism. Seth Govindas, Speaker of the Constituent Assembly, delivered a forceful argument for deletion of sedition from the draft constitution as follows. My great-grandfather had been awarded a gold waistband inlaid with diamonds. The British government awarded it to him for helping it in 1987, and the words "in recognition of his services during the mutiny in 1987" were engraved on it. In the course of my speech during Satyagraha movement 1930, I said that my great-grandfather got this waistband for helping the alien government, and that he had committed a sin by doing so, and so that I wanted to have engraved on it that the sin committed my great-grandfather in helping to keep such a government in existence had been expiated by the great-grandson by seeking to uproot it. For this I was prosecuted under 124(a) and sentenced to 2 years imprisonment. However, though there was great opposition to include sedition as one of the restrictions on free speech, and it was rejected forcefully by most of the members of the Constituent Assembly, 124 still remains on the statute book and is being misused increasingly. However, Section 124 remains in the statute, and successive elected governments have happily and indiscriminately used the offending clause to throttle voices of criticism. Challenge to Section 124 was rejected by the Supreme Court in Kedarnath case. That was in 1956. However, the said judgment laid down certain governing principles for the guidance of the courts and the state. This is what their lordship said. There can be no doubt that apart from the provisions of Clause 2 of Article 19, Section 124(a) and 505 are clearly violative of Article 19(1)(a). But for 19(2), their lordship say that it's clearly violative of 19(1)(a) of the Constitution. But then we have to see how far the saving clause, namely Clause 2 of Article 19, protects the sections aforesaid. Now, as already pointed out, in terms of the amended Clause 2, quoted above, the expression "in the interest of public order" are words of great amplitude and are much more comprehensive than the expression for the maintenance of law and order. As observed by this court in the case of Virender Singh versus so-and-so, any law which is enacted in the interest of public order may be saved from the vice of constitutional invalidity. If, on the other hand, we were to hold that even without any tendency to disorder or intention to create disturbance of law and order, by the use of words written or spoken which merely create disaffection or feeling enmity against the government, the offence of sedition is complete, then such an interpretation of the section would make them unconstitutional in view of Article 19A read with Clause 2. It is well settled that if a certain provision of law is construed in one way, it would make then their lordships go on to read down and say that, as already pointed out, the explanation appended to the main body of the section makes it clear that the criticism of public measures or comment on government action, however strongly worded, would be within reasonable limits and would be consistent with the fundamental rights of freedom of speech and expression. It is only when the words written or spoken, which have the pernicious tendency or intention of creating public disorder or disturbance of law, and the order that the law steps in to prevent such activities in the interest of public order. So construed, the section, in our opinion, strikes the correct balance between individual fundamental rights and the interests of public order. This particular para where their lordships have laid down certain limitations on 124 qua 19.2 seems to have been forgotten. Nobody seems to remember, neither the prosecuting officials nor the courts, that there is a distinction which has been made out. If that distinction is crossed, it becomes violative of Article 19.1A, right? In spite of saving clause in 19.2. And if it is within the bounds, as explained by the Supreme Court, it can be upheld. But if a prosecution is launched against somebody, alleging that he has made a seditious speech or his actions amount to sedition, whether they amount to sedition or not, whether the speech consists of seditious words or not, would take at least a few years, if not a few decades, for the courts to decide. In the meantime, he will be an accused. He's lost everything. He's lost everything. Once a person is accused of sedition and becomes a criminal in the eye of law, ignoring the principles laid down in Kedarnath case, cases are launched indiscriminately invoking 124A. A database called article14.com shows that 10,958 individuals were accused of sedition since 2010. 10,950 individuals doesn't sound huge in a country that's. But how many individuals do actively participate in political campaign? How many individuals do actively espouse the cause opposed to the governmental policies? So if you look at the people that participate in these public discourses and then compare the figure that have been arrayed as accused in 124 cases, it's really huge, really huge. It's difficult to pursue, but it's a fact that a few thousand agitators were booked under Section 124A who are protesting against setting up of a nuclear plant in Kudankulam. Can you imagine that a group of persons, a few thousand people who went to protest against setting up of a nuclear plant, all of them being accused of sedition? Of course, subsequently, Viceroy Council probably have prevailed over the government, or maybe government changed. This case was withdrawn. Similarly, cases are registered under Section 105 for drawing cartoons and publishing the same on the internet of chief ministers or other powerful political personalities, casting doubts about their integrity. I recently appeared in a case where a powerful politician of this state a spoof was published on the Facebook of a particular organization which is helping the opposition party to propagate against the government. The spoof shows that it's from the Maya Bazaar cinema, where Sachireka opens a box and sees Abhimanyu, and then sees Relangi opens the box, he says Rakshasa. So in this spoof, when the box is opened, you'll find the man looking at liquor bottles. You'll find in in the next picture, it's shown that somebody else very closely related to him carrying money bags. The third one is something like that. Immediately, complaint was lodged, and the organization, which has nothing to do with the politics, they were only creating content for the purpose of propagation. Police raid the office of the content creator. They book them under 505. That's creating enmity between two communities. I don't know how you publish a cartoon, how does it create enmity between two groups? Two groups of persons. And 463, I think, it's forgery. They say that it's forgery. So these are the sections, once they are alleged, once this allegation is made, they will not be able to get bail. The country seems to be losing its sense of humor completely. That's all I can say. And publishing the same on the internet of chief ministers and other on the internet of chief ministers or other powerful political personalities, casting doubt about their integrity. Examples gather of concerted and vicious attacks on the right to free speech and expression. It's the duty of the constitutional courts, being the sentinels, to ensure that citizens and their fundamental rights, more particularly the ones guaranteed under Article 19(1)(a), are protected to the fullest extent. It is observed in the recent judgment of the Honorable Supreme Court in Kaushal Kishore, as a constitutional bench of the Supreme Court, that the role entrusted to the constitutional courts is to be a gatekeeper and a conscience keeper, to check strictly the entry of restrictions into fundamental rights. The role of the court is to protect the fundamental rights, keeping in mind the restrictions which are lawful and not to protect the restrictions. It is held by the apex court on more than one occasion, in more than one case, that any restrictions ought to be imposed will have to be justified by the state as reasonable, and also ensure that no additional restrictions are imposed which cannot be directly traced to the restrictions on the fundamental rights envisaged by the Constitution. It is not for the citizens to establish that a restriction placed on the fundamental right is unreasonable. The burden is placed on the state to justify its actions are reasonable, but that doesn't seem to be happening at all. Now I end this lecture with a poem by Guru Rabindranath Tagore, where the mind is without fear and the head is held high, where the knowledge is free, where the world has not been broken up into fragments by narrow domestic walls, where the words come out from the depth of truth, where the timeless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert and the dead habit, where the mind is led forward by thee into the ever-widening thought and action into the heavens of freedom. My Father, let my country awake. I would say, let the courts keep the country awake. Thank you very much.
Thank you, Mr. Mohan Reddy. That was you covered a wide panorama of a very complicated, challenging theme. While as a lawyer, during my service on the bench, thereafter associated with academics, trying to share thoughts with judges, when I was serving in Bhopal, this dilemma always was there as to why is it that very few people can get together for long. And a study of history tells us that all civilizations are a story. Some have a paragraph, some have a sentence, some have only a punctuation mark. Today we talk about the Phoenician civilization, we talk about the ancient Chinese civilization, the Egyptian civilization, the Greek civilization. We are just infants at 70 odd years, and how soon we'll become a story depends on how less delusional we are. 2 million years ago, Darwin and Mendel tells us that our ancestors came down from the trees, and in the process of physiological evolution, we lost the tail. The tailbone still remains and haunts us when we are old. The tail has gone into the cranium. So many of our behavioral patterns do not accommodate a large number of people gathering and living together in harmony. We become idiosyncratic, and this is what the Jewish historian Yuval Noah Harari also says. So it's always a problematic. Today we believe, while there's a lot of insecurity in our public institutions, and they cannot accommodate a contrarian voice. And there are many enemies of our democracy. Apart from the three formal institutions, a bigger threat is also from the fourth estate. And we now seem to have a very strong and deeply felt disbelief in the right to free speech. And that is a fundamental right. A right not to have freedom of speech has become fundamental. And what is more, all of us share, or a lot of us share, the right to irrelevant speech. And that is a problematic. When I was a young lawyer, even by that time there was a regress. We used to say, I'll not name in a public meeting, privately I can share. In those days there were two newspapers. If you read both the newspapers, perhaps if you distill the contrarian stories in the two the news reports in the two newspapers, you will perhaps arrive at the truth. But today, even if you read 10 newspapers, you will get 50 different varieties of falsehood. Truth always eludes us. So there is a lot of abuse of this freedom also, and many of your liberties are construed as licenses to behavior. Thank you, Mr. Mohan Reddy, for a very comprehensive and panoramic survey in the possible 1 hour's time that were given, and we have a tradition of inviting Q&A, question and answers. If any members of the distinguished audience have any questions on the theme of today's address, the distinguished speaker, Mr. Mohan Reddy, will be glad to have a discourse. Thank you. Yes, sir.
My name is Chengal Reddy. I am a farmers activist. My question is not to Mohan alone, but to the distinguished participants today. See, there is a great deal of trust deficiency in the whole country, so especially in the last few years. And I am a farmer. As a farmers activist, I find that India is today similar to Roman Empire. We have nobles and slaves, that is organized and unorganized sectors. Having said that, all that I would like to suggest to the distinguished audience is today the three constitutional institutions are, in my view, not that very effective or functional. Is it possible for these eminent jurists and others to establish some sort of a think tank and seek public opinion by way of referendum? Is it possible for all of you to consider? Because the principle of democracy itself is evolved only in the last 200 years. Today the democracy itself is in a problem. I mean, that's my view. One I would like to suggest is it possible for eminent people other than the Constituent Assembly to evolve a system wherein you seek public opinion, have some sort of a referendum Is it possible? Can it be considered?
I'll share a personal view, sir. Uh, I don't think society in general, there may be cosmic exceptions. Society in general is willing to accept cognitive leadership of some. There was a time when you had people whom you revere for their intellectual capacities, for their philosophical dispositions. But today, everyone is a university in himself. And universities have today regressed into schools. We call it a law university. A university is a confluence of various disciplines. But today we have atomic. India itself is called a nation by the constitutional edict. We are 1.38 billion atoms masquerading as molecules. So it is difficult to conceive. And then I realized not very long compared to many revered seniors that were here with my about 4.5 decades of association with law and sociology. Why is it that we behave so? Then I was reading up other areas, disciplines like mathematics and theoretical physics and particle physics and all that. And then slowly I am coming to learn that at some particulate level, now there is a theory of strings of energy vibrating at the fundamental level, below the atomic level. And all these fertilize the consciousness. Each of them have the consciousness. And the law that governs the physical universe is the second law of thermodynamics, from order to chaos. The law that governs social universe is also order to chaos. All over the world, we revere nationalism. In a world that is brought increasingly together by mass migrations, by economic confluence, we still talk about nationalism. There is hardly the sovereignty of Austin kind anywhere in the world. No country is sovereign in itself, either economically or geopolitically or arms-wise or in any other dimension. We are an interdependent society, but still we romance nationalism. That itself is a counterintuitive behavior of individuals in the aggregate. I don't think society is ready to accept the leadership of anybody. In fact, even in religion, if you go, every religion has got 1,000 dimensions today. There is no single acharya anywhere. And this happens even in our judicial branch. I was talking to judges as to why is it there is so much of discordance. Judges don't follow other judges even if it's a binding authority, larger bench or somewhere. So some judge was telling us it is something to do with a religious tradition. Once you join a ashram, after 1 month you feel that after 6 months or 2 or 3 years you feel that you are a bigger acharya than that acharya, you establish another matam. So each judge believes that he is the fount of all knowledge. He wants to disagree. Though stability is a principle of law, very important principle of law, there is more contribution to dissonance and disharmony, jurisprudential disharmony, than harmony by the superior courts. So if you consider institution by institution, we find that we are incapable of accepting the leadership of anybody, even intellectual or philosophical leadership. And a society, if you examine the world today, the last Indian or philosopher of repute that we know of is Jiddu Krishnamurti. Now we only have CEOs of multinational companies, some of whom are in the nation of their origin, some of whom they escape to take away their stashed wealth using the freedom of movement, another protected constitutional right. But you don't have philosophers who guide you as to what's happening with the world, what ought to happen with the world, what's wrong with the world. So a country, a society and a world which does not produce philosophers is destined not to have a moral or ethical fundamental principle on which the society can coexist peacefully. I don't think it's possible. In fast food joints, you can't produce Michelin chefs. That's my view. Yes, sir.
So good. Little louder, sir.
He's getting weak.
Good evening, sir. I am Justice Chandraya, former judge of the High Court. One question from the sociological point of view. Now, the law is the superstructure of the society. From that point of view, a judge is supposed to know about the all angles of the social structure. Judiciary is one of the structure. In such a case, if you read the life history of late Alladi Kuppuswamy, his social service point of view, apart from the judicial life, as a judge, as a chief justice, his lordship was a member of many associations of social organizations to do a social service. But in the present era, we are talking about about 60 to 70 years ago, a life of a judge. But in the present system, the social service of the judges outside the court is diminishing, where the social structure demands that the intellectuals in the field of adjudication process or justice system, a great responsibility cast. But they are not coming forward to contribute for the social harmony and to resolve the differences of. It is a question. So, the part of the life of late Alladi Kuppuswamy, who led a life as a judge, a life as a social servant, from this point of view, he happened to be a member of several organizations and served the society. From that point of view, I want to know something about the service rendered by late Alladi Kuppuswamy in serving the society other than as a judge.
There could perhaps be other occasions for that. In my introductory speech, I have referred to certain extrajudicial associations, both during his active service life and after retirement also, that Justice Kuppuswamy was associated with, including literary and charitable organizations, founding of endowments and things like that. So there are several activities. There is a brief book. It's an autobiographical note written with his indelible style of humility and simplicity that you could pick up there. They're available. There you'll get a more comprehensive and wider account of Justice Kuppuswamy's extrajudicial, extra-legal associations. That's it, I guess. Yes, sir.
సార్ నమస్తే, నా పేరు రెంటాల జయదేవ. సార్ మీరు ఇందాక మాట్లాడుతూ దర్ ఇస్ ఎ బిగ్గర్ థ్రెట్ ఫ్రమ్ ది ఫోర్త్ ఎస్టేట్ అని చెప్పేసి చెప్పారు, అపార్ట్ ఫ్రమ్ ది అదర్ 3 ఇన్స్టిట్యూషన్స్. ఐ థింక్ జ్యుడిషియరీ మీద కూడా ఇప్పుడు చాలా వరకు అనేక రకాల ఆరోపణలు, తర్వాత రిటైర్ అయిన తర్వాత కూడా వాళ్ళు పొందుతున్న బెనిఫిట్స్ మీద కూడా రకరకాల అనుమానాలు కూడా ఉన్నాయి. దీని మీద ఏమంటారు? ఒకటి మీకు, తర్వాత మోహన్ రెడ్డి గారిని కూడా నేను ఒకటి అడగదలుచుకున్నాను. డిసెంట్ గురించి, డిసెంట్ అండ్ ది కాన్స్టిట్యూషన్ ఆఫ్ ఇండియా గురించి మీరు చెప్పారు, అలానే సెడిషన్ గురించి చెప్పారు. ఇవాళ బిగ్గర్ ప్రాబ్లమ్ సెడిషన్తో పాటు లేటెస్ట్గా కూడా డిఫమేషన్ కూడా, క్రిమినల్ డిఫమేషన్ అనే పేరు మీద ఎవరినైనా ఏ రకంగా అయినా కూడా డిస్క్వాలిఫై చేయొచ్చు అనేటువంటిది ఇవాళ కూడా మనం చూసాం. కాబట్టి దాని మీద గురించి కూడా మీరు ఏమన్నా కాన్స్టిట్యూషన్లో ఏం చెబుతోంది, ఏం చేయాలి, ఏం చేస్తే డిసెంట్ వాయిస్ వినిపిస్తూనే డిఫమేషన్ని తప్పించుకోవచ్చు. థ్యాంక్ యూ.
Perhaps you missed what I said. I said the threat to our democratic fabric is not only from the three formal institutions, but also from the fourth institution, the fourth estate. I did not say that the three institutions, formal institutions, were not contributory to the regress of democracy. They are. And the fourth estate is not, in fact, the freedom of the press is not a protected right. It's a derivative of the freedom of speech. So just as we have now we believe in the fundamental right to irrelevant speech, the fourth estate also by and large appears to believe in the propagation of a Bahubali spectre of society, graphics and vituperation. It seems to participate instead of being the monitor of truth, it becomes a propagator of partisan views. By and large, there are exceptions, always cosmic exceptions are there, but they are getting increasingly cosmic. That's the problem.
Sir, my name is Jeevan Kumar.
Second part of his question is directed to me. మీ పేరు నాకు తెలీదు. ఆర్టికల్ 19(2)లోనే ఎక్సెప్షన్ ఉందండి డిఫమేషన్కి. ఇట్స్ వన్ ఆఫ్ ద లిమిటేషన్స్ ఆన్ ద రైట్ టు ఫ్రీడమ్ ఆఫ్ స్పీచ్. బట్ దెన్ వాట్ యు ఆర్ టాకింగ్ అబౌట్ ఈస్ defamation as a criminal offense. I think defamation as a criminal offense has to go out of the statute book. It certainly sends chill down the spine. Even as I am speaking, I don't know if I might have said something tomorrow morning, somebody might lodge a complaint against me and I am liable to be prosecuted. So that has to go out of the statute book. Defamation is a limitation prescribed under Article 19(2). Therefore, there are channels open. You can go to civil court, you can claim damages. And most of the democratic countries, subject to correction, defamation as a criminal offense is not there in their statute books. That's only because it's likely to be abused, and it's abused in very many countries where defamation is remained on the statute book as a criminal offense. Therefore, there is a limitation on the freedom of speech. It's subject to defamation, but then 120, the provision which deals with defamation, criminal defamation, 501, 502, I think, they'll have to go out of statute. That happens because that's there in the statute book.
Sir,
And to add a note to Jayadev Garu to what you said, I personally believe that the judiciary is the ICU of a democracy, intensive care unit of a democracy. And I believe that the fourth estate, the media, is the ECMO of democracy, extracorporeal membrane oxygenation, which Balasubramaniam had and actor recently had. Now we find corruption and corrosion both in the ICU as well as in the ECMO, corporatization of fundamental values, and therefore there is no remedy.
Sir, my name is Jeevan Kumar. I am a human rights activist. Sir, you explained well the restrictions of freedom of speech and other things. But as a citizen, I always feel that I am very weak before the state. State is very oppressive. I also feel that these restrictions are giving impunity to state, which are again protected by the court. Court is also protecting the impunity of the state. So, as a citizen, where should I go to get my rights defined and enjoy my rights? Do courts come to my rescue or not? Courts are not coming to my rescue. Courts are going to rescue the state, and state is given impunity by the courts also. This is my charge.
if your fundamental rights are invaded or any other constitutional rights are invaded, you have right to invoke the jurisdiction of the High Court under Article 226. Second part of your statement that the courts are not coming to the rescue of citizens may not be entirely true. I pointed out in my speech certain judgments of the Supreme Court where the courts have upheld the fundamental rights, have come to the rescue of citizens, protecting free speech and free expression. I am sure courts will certainly come to the rescue of citizens. I have not come across a case where courts have not condemned excessive action by the state. Maybe there are instances, yes. There are always aberrations. Every institution has certain weaknesses. It's part of the game.
One wishes that such a lecture, such a question and answer session never comes to an end. Because these are all very thought-provoking questions, thought-provoking ideas that have been given to us. And I wish we all had, they're all, they would be here with us and we can discuss for a very long time. But all good things have to come to an end. A good man like Alladi Kuppuswamy had to come to an end too. I thank Mr. Mohan Reddy. When he was telling me that he used to come for the arbitration, I now vaguely remember his coming home to the arbitration. I didn't realize that the Mohan Reddy then and he was the same person. Yeah. So anyway, I'm glad he brought back those memories to me, because I've lived with my father the last 27 years of his life. So I know most of the people who come there. But I must thank you very much for this lecture, which for me is the essence of my father. So thank you very much, Mr. Mohan Reddy. To question, to think, to question. And Justice Raghuram Garu was talking about misuse of freedom. But what is life if there is no freedom? And with everything comes use or misuse. And it also depends upon who questions the use of it or the misuse of it. What is used for one may not be, would be a misuse for another. So it's a question that one has to think very, very carefully. I worked in a university for a very long time. So a university is supposed to be a place where you have ideas, you think of things, you debate. But now, most often, everything is closed. So that's a very, very sad state. And so I do want people, there are some younger people, but I do want younger people to think that there is a need to question, not just for the sake of questioning, but because we genuinely believe that certain things have to be questioned. So thank you very much, both Mohan Reddy Garu and Raghuram Garu, who have waited 3 years patiently, bore with us, and have come here to give you this wonderful Jugalbandi. Thank you very much, both of you. I thank the audience, and I particularly want to say something which was brought to me very interestingly, that my father celebrated his father's centenary in 1983 in this very auditorium. And at that time, Justice Jagannath Rao Garu and one of his very close friends, who's also his bridge player with him, Mr. Jogeshwar Rao there. Mr. Jogeshwar Rao brought this to my memory, and so I thank you all. I particularly feel thrilled that my father's centenary is also being celebrated in this very venue with these two people here. I thank the audience for coming here and responding to our invitation, and especially the judges who have retired judges who have taken the trouble in spite of their health and other things. And I want to apologize here to Justice Venkatram Reddy if he's still there. I believe he went, or I mean, it said that Telugu University is in public gardens, or somehow he got the impression, and he went around public gardens 3 times before he ended up in the Telugu University auditorium. I'm very sorry for this, but I still thank you for having made it and having sat with us through the lecture. I thank the academics. I don't want to name anybody in particular. I want to thank the lawyers. I want to thank the academics. I want to thank the activists. I want to thank my family, my larger family, my extended family. I want to thank all of those who have responded to this invitation, without whom this would not have been a success today. I also thank the media for responding so very well to us and to have taken the time to come here and attended this lecture. But most of all, I thank Telugu University. If they had not given us a hall, we could not have had this lecture. I thank Telugu University and Mr. Chandu in particular, who has made things very possible for us and has made everything comfortable. I thank Mr. Rupani for sending his young person across who is video recording it, and we hope to put it on YouTube so that those who could not attend it today would have the chance of listening to this very thought-provoking lecture. Thank you all very much. And I now request Sridhar, as a token of our appreciation, to give a small memento each to Mr. Mohan Reddy and to Justice Raghuram. Thank you all very much. And as I said, all things have to end. And I wish you all a very happy rest of the year. And this is soon after Ugadi. And so a happy Ugadi to you. And good night to all of you.